Good afternoon, everyone. Thanks for joining us this Saturday afternoon for our webinar on perspectives and insights on current issues and developments in international arbitration. My name is Smita Menon. I'm from Wong Partnership in Singapore. And before we begin, I'll introduce the panelists that we have today. So first, Ms. Anuradha Dutt, a senior partner and founding member of DMB Advocates. She's the managing partner of its Delhi office and is a seasoned lawyer with 36 years of experience in representing clients in litigation and arbitration, one of which I've been involved in with her, so I can attest to her brilliance. Ms. Dutt has and continues to be involved in both domestic and international arbitrations administered by all the premier global institutions, including the ICC, LCIA, PCA, and of course, SIAC. Now, moving on to our European panelist, Dr. Claudia Annika. She's a partner at Cleary, Gottlieb, Steen, and Hamilton. Her practice focuses on international litigation and arbitration and public international law matters, including investor-state disputes, disputes involving international organizations, state succession issues, and state immunity, as well as disputes before the European Court of Human Rights. And now Ms. Sharina Petit. She's an international arbitration partner at Norton Rose Fulbright. She leads the practice across Asia, Europe, and the Middle East, and of course the firm's India practice globally. Sharina has varied experience in representing clients across industries in numerous commercial and investor-state arbitration proceedings, litigations, and other ADR mechanisms. She also regularly sits as an arbitrator. And rounding off our panel is Ms. Gauri Raskotra, who's the Deputy Head of Dispute Resolution at Cyril Amarchand Mangaldas in Delhi. She has over 2 decades of advisory and litigation experience in both academic and corporate settings. The landmark cases she's litigated includes the right of citizens to fly the national flag. She also worked on the revival of Satyam Computer Services under new management after its scandal, which was the largest ever corporate scam in India. So since we don't have that much time, I thought we'll go straight into the session. And we're starting off with the heavy-hitting topic of investor-state dispute settlement. And I'm going to hand the mic over to Dr. Annika to give us her perspective on the developments from the European perspective. Claudia?
Thank you, Smita. Investor-state arbitration is currently in a state of turmoil in Europe. In the midst of the COVID-19 pandemic, on May 5th, 23 EU member states signed a treaty to terminate all of the bilateral investment treaties in force among them. The termination treaty gives effect to the ACMEA judgment rendered by the European Court of Justice in March 2018. That judgment held that investor-state arbitration under intra-EU BITs is incompatible with European Union law. Now, upon entry into force of the termination treaty, more than 130 intra-EU BITs will terminate. Our sunset clauses, which would otherwise have locked in treaty protections for existing investments for a period of typically 10 to 20 years, will also terminate. That means that investors from one EU member state that have invested in another EU member state will lose intra-EU BIT protection, including the right to resort to investor-state arbitration. Now, I would interject that the effect of this termination of sunset clauses by way of the termination treaty will likely become a controversial issue to be decided by arbitral tribunals constituted under intra-EU BITs. Our respondent states will take the position as masters of their treaties. They may freely terminate treaties, including sunset clauses. Investors may argue they may not be deprived of vested treaty rights, and indeed there are some sunset clauses that by their express terms apply even in the event of a mutually agreed termination. Now, the end of intra-EU BITs comes at a time when it is critically important to foster cross-border investment in Europe. Before the COVID-19 crisis, the European Commission has taken the position that European Union law offers adequate investment protection. Now, that position was vigorously challenged by large European investors, but also by some EU member states. They have called for protections similar to the ones accorded by bilateral and multilateral investment treaties, including in particular the right of investors to directly enforce these protections against the host state. This week, the Commission launched a public consultation on investment protection in the European Union. There is thus an opportunity that the current system, a highly fragmented bilateral investment treaty protection system, may be replaced by a multilateral pan-European system. Now, the COVID-19 crisis may also be expected to reinforce a trend in the investment treaty practice of the European Union and also its member states, namely the trend to strengthen the host state's right to regulate in the public interest. The EU-Singapore Investment Protection Agreement, for example, already expressly reaffirms the contracting parties' right to regulate in the public interest and specifically to regulate to protect public health and safety. Now, this trend is also reflected in the most recent proposal of the European Commission, a proposal of April 20th, for the renegotiation of the Energy Charter Treaty. And interestingly, in light of the very substantial increase of public debt during the COVID-19 crisis, the European Commission also proposes to largely exclude claims arising out of sovereign debt restructurings from investor-state dispute settlement. Now, on top of the COVID-19 crisis and the termination of intra-EU BITs, the European Union is sorting out its future relationship with the United Kingdom. A draft of the free trade agreement between the EU and the United Kingdom was published this month, but this draft does not contain any ISDS mechanism, and it also scales down substantially on substantive protections. The BITs that are currently in force between the United Kingdom and certain EU member states, those BITs are likely to remain in force. The United Kingdom did not sign the termination treaty. And after December 31st, 2020, its BITs with EU member states would no longer be treated as intra-EU BITs. They would thus not be affected by the European Court of Justice's ECMIA judgment. Within the European Union, each EU member state, not the European Union, is competent to declare health emergencies and to adopt measures to combat COVID-19. So each of the 27 EU member states has adopted different measures. These measures span restrictions on or outright closures of businesses deemed non-essential, quarantine measures, requisitioning of goods and services, and deferral of rental payments and loan repayments. So there's clearly a potential for investment treaty claims to be brought against EU member states. Many EU member states have an extensive BIT network with third states, and these investment treaties are not affected by the termination treaty. The proportionality of certain restrictive measures has already become controversial. Protected investors may thus argue that particular measures were disproportionate in breach of the fair and equitable treatment standard. Investors may also argue that they have been forced to close down their operations. Thus, they are entitled to adequate compensation, given that such measures may be characterized as being expropriatory. Since the measures to combat COVID-19 had to be taken swiftly, we may also see claims by investors that they have not been accorded due process, or that the decision-making process was not transparent. Most EU member states are currently granting very considerable financial support to affected businesses, including subsidies, tax relief, lending facilities, or even recapitalization. So foreign investors that were denied financial support, they may seek to bring discrimination claims where such support was made available to domestic competitors in like circumstances. But such investment treaty claims would have to satisfy a high burden to succeed. In many cases, respondent states will have effective defenses. Most of the measures taken are likely a non-compensable exercise of the state's police powers. Now, even if an investment treaty does not expressly reaffirm the contracting party's right to regulate in the public interest, as more recent investment treaties do, arbitral tribunals should be reluctant to second-guess governmental judgments that respond to an unprecedented crisis, often laced with contradictory scientific opinions. We may also see the WHO and NGOs intervene in support of respondent states in future investment treaty arbitrations. Now, in addition to the right to regulate, host states may also rely on essential security clauses in investment treaties. Now, these clauses authorize the contracting parties to adopt measures that would otherwise be in breach of their treaty obligations, but which are necessary to protect their essential security interests. Tribunals have applied such clauses outside the confines of security issues, and there are also certain clauses that expressly refer to the protection of public health. The India-Mauritius BID, for example, features such a clause. Finally, host states may be able to defend against investment treaty claims by invoking state of necessity. State of necessity as a circumstance precluding wrongfulness under customary international law, not under the investment treaty itself. But the host state would have to demonstrate that the measure in breach of its treaty obligation was the only way for the state to safeguard public health and safety against a grave and imminent peril. Now, as the cases brought against Argentina in the wake of its financial crisis illustrate, it may be quite difficult for the host state to meet that high standard. This concludes my remarks from a European perspective, and I would now turn the floor to Anu to address the Indian perspective. Thank you very much.
Thank you, Claudia. I think not only Europe, but the world is actually at the crossroads in investor-state dispute resolution. We find that many states are speaking against it. China has also asked for certain measures like appeal process against awards. I'm told that UN has a working group which is looking now at a prevention of disputes aspect. But let me take you to India. India has a very different way of reacting. So in 1980s and 90s, when India was wanting to attract capital from outside, then it entered into some 88 or 90 odd bilateral investment treaties. But now, today, India sees itself as a big market which multinationals cannot afford to disregard. So they think that they can do without these special, rights that they give to the investors, and have in fact now unilaterally terminated about 50 odd treaties out of the 80 plus treaties. The other thing that they have done, India has done, is a little peculiar. They were actually slapped with about 8 to 10 bilateral investment arbitrations. So what they did in 2015 was they came out with a model treaty which actually tried to undo each of the treaty arbitrations that had been initiated against it. But I want to take you through two treaties which I think show where India is going. The first one of them is India-Belarus. Now, in India-Belarus, what India has done is, which Belarus also, I have to say it's not one way, it's a treaty. So what Belarus has also accepted is that they have firstly introduced the Salini test, which was only in exit cases, and in fact in unilateral cases that was being watered down in several awards like Deutsche Bank versus Sri Lanka, etc. But this treaty now accepts that Salini test and also puts a substantial business test, substantial business activity test. Now these are, some method to try and narrow the scope of bilateral investment arbitration. The most interesting thing is that they have, in this treaty, actually got a clause where denial of justice, which is one of the most fundamental international wrongs that is accepted, has been done away with. And they have got a clause where they say that judgments of courts in India will not be challenged in any arbitration, bilateral investment arbitration. The good part, I must also point out, is that there was a lot of pressure to say that multinationals which come to your country must also bring in international norms of environment, labor, etc. That has been made now a part of the treaty, which of course is a positive part. But another extremely significant change is in the dispute resolution. We now have preconditions which were not there, and preconditions that there must be an exhaustion of local remedy, and the period given is 5 years before you can invoke a bilateral investment treaty. I don't know how effective this is going to remain. But what is more important is the India-Brazil treaty. India-Brazil treaty actually does away with dispute resolution through arbitration for investor and the state. We no longer have this available in this treaty. Now, I must say that Brazil is also, I must point out that Brazil is also one of the countries which has suffered several awards against them. And so a common interest between India and Brazil now sees a shape of this treaty. Now, in this, I would like to point out that what they do is they now do what is called dispute prevention. So although all the international obligations and rights are given in it, that is FET, expropriation, denial of justice, but you can't enforce it. So they have now, in India-Brazil treaty, they have got a committee of 2 countries which will look into dispute prevention. They will look into the various disputes that have come. They will also have an ombudsman, each of the countries, so that they look into the contracts and how they are being implemented. But what's important is that the arbitration, as I mentioned, is only between 2 states and not between an investor and a state. Now, I personally see that maybe bilateral investment treaties do need some reform, but to give rights and take away enforcement, to my mind, is really making them toothless. And as I mentioned earlier, United Nations, yes, is planning to introduce dispute prevention, but I don't think that can be a substitute. That definitely can be a precondition, but to make it a substitute, I think the treaty is really becoming a toothless treaty. And as I said, in my view, this really is a step in the wrong direction. Yes, I agree that as our political class in India and our bureaucracy thinks that any investor who's coming to India is not coming because of the laws or the tax laws or the international laws or the treaty, but is coming only because of the market. And therefore, they have to now subjugate themselves to all the laws that are prevalent in our country. I'm not sure I agree with this argument, because even recently when JET, which of course now has gone, but a couple of years ago when JET was getting money from UAE, they insisted on a treaty being signed. So I don't think Indian ruling elite, that is, I mean the political class and the bureaucracy, is right in thinking in this manner. Yes, do reform, but don't make it toothless, and all the international wrongs can just be thrown away by the side. Thank you.
Thanks, Anu, and thanks, Claudia. For all those listening in, if you've got questions for Anu or Claudia on what they've covered, please use the Q&A function and type in your questions. We'll deal with all questions at the end. Okay, so while you think on what they've said, we're going to move on to the topic of technology in international arbitration. I mean, people always say that lawyers are the most resistant to technology, but with COVID-19 and the imposition of safe distancing measures, both courts and tribunals worldwide have had no choice. Everyone's been forced to utilize technology for their hearings. Now, since we expect safe distancing measures to continue in at least the foreseeable short term, and the fact that everyone's discovered the pros and benefits of using technology and how it's more efficient, greater productivity, technology, I think we can all assume, will definitely shape the practice of international arbitration in the foreseeable future. So on that note, I'm handing the mic over to Sharina to give us her perspective on this topic. Sharina?
Thanks, Smita. Smita, as you just said, I don't need a crystal ball to look into the future to see that 2020 will be considered the turning point in the world for a new way of the administration of justice. With travel restrictions remaining in place, across the majority of the world, and with the introduction of safe distancing measures, as you mentioned, Smita, it is clear that the new normal is going to continue to impact the way we work, at least for the foreseeable future. In light of this, individuals, companies, our clients, lawyers, arbitral institutions, courts have been and will continue to rely upon technology to ensure business as usual. Arbitral institutions and courts will, in this new normal, need to fulfill their commitments to companies, to people who have enlisted them to being cost effective and time efficient in providing the dispute resolution service that they seek to provide. Given this, I will today, within the 10 minutes allotted, be touching upon a few different topics. One will be document management systems and e-bundles. 2, virtual hearings. 3, some protocols and guides to best practices. And 4, how technology can help with the types of disputes arising out of COVID-19. So let's take topic 1, document management and e-bundles. Document management. The benefits of electronically preparing for a hearing might be obvious, but should not be underestimated. Having an online document management system at the very outset of proceedings can make the management of documents much easier for parties, saving time and reducing costs. And this is obviously for a number of reasons. One is it allows parties to manage a large number of documents in a short span of time. 2 is that it provides useful tools to search, to annotate, to share materials between clients, counsels, experts, witnesses. The convenience of having exhibits hyperlinked with pleadings or witness statements is incredibly useful and time-saving. Moving on to e-bundles. Obviously, in addition to document management system, it's a clear time and cost-saving benefit. This is particularly so in document-heavy, multi-party and or multi-arbitrator proceedings. I remember when I was a trainee sitting in the document production room, churning out with the document production, all these bundles, hard copy bundles for the tribunal, for the other side, bundles for our clients. I wish at that time there were e-bundles. If an e-bundle is set up early and documents are uploaded as and when they are served, the hearing bundle will automatically be constructed during the course of the proceedings. Moving on to the court's encouragement, the advantages of conducting pre-hearing preparation electronically has also been recognized in court proceedings, with courts increasingly encouraging parties to consider technology to ensure disputes are managed in a cost-efficient manner. So, for example, the UK has taken, the UK Civil Procedure Rules has introduced a pilot scheme which encourages parties to opt in to issue proceedings and file documents online rather than on paper. The UK judiciary has also, in order to achieve a level of consistency, recently introduced guidance on PDF bundles for use by judges in hearings. This contains requirements such as the fact that these bundles should have OCR, so that optical character recognition, so that documents become word searchable and all significant documents are bookmarked or hyperlinked to the index. Coming on to topic 2, virtual hearings. I think the most noticeable way in which technology will impact arbitration and court hearings is the use of virtual hearings. Interestingly, most arbitrators were unfamiliar with virtual hearings, and I was looking up some statistics. So while some arbitrators may have experienced cloud-based document sharing, the Queen Mary University in 2018 took out a survey and found that 78% of the arbitrators had never or only rarely taken part in hearings where all participants were in different locations. Now, it's obvious, given the world that we live in today, that that has changed. The coronavirus pandemic is requiring the arbitration community to adapt rapidly to a reality that will be with us for the medium or long term, and virtual hearings will be the new normal. So what's the arbitration institutions doing? The arbitration institutions have sought to encourage and support parties to use virtual hearings during a time when most in-person hearings are impossible or impractical. In an unprecedented move, a number of institutions made a joint statement on arbitration and COVID, committing to support the international arbitration community and ensuring that pending cases may continue and that parties may have their cases heard without undue delay. In particular, this joint statement emphasized the importance of collaboration as institutions look to make use of digital technology for working remotely. I know SIAC has made offerings of e-hearing services. So, for example, SIAC is directing its users to Maxwell Chambers' virtual alternative dispute resolution hearing platform, which allows Singapore-based parties to conduct hearings with overseas parties via video conferencing facilities. It also grants worldwide access to arbitration materials on a secure cloud-based platform. I would like to go on with lots of pros and cons of virtual hearings, but unfortunately time is short. And so if I had to pick one pro, besides the obvious need for reducing time and cost, I think it would be the reduction of carbon footprint. And in fact, Lucy Greenwood, an eminent arbitrator, started a campaign for greener arbitrations last summer actually, which has now taken the form of the Green Pledge, where she noted the significant carbon imprint of the arbitral community. And she asked the community to sit back and think, do they really need to go and fly for that hearing? Can they do it by video conferencing? Can they reduce that carbon footprint? If I was to think of one con, I would sadly think it is the loss of in-person observation of witness testimony under cross-examination. I think it's just going to be, it's simply difficult to capture that look, the feel of the witness online, their body language, their facial expressions, the nuances. There's concern that the witnesses may be being coached off camera or reading from a script hidden from the tribunal's view. And there are other cons as well, like breaches of security, confidentiality, and enforcement of awards delivered via email without wet signatures. But what are the courts doing? It's worth noting that the courts across the world have recognized the importance of virtual hearings for the proper administration of justice during this global lockdown. The UK government has released a statement stressing the importance of the proper administration of justice in England and Wales, emphasizing that courts should continue to operate. The English High Court and the Court of Appeal is continuing to hear all urgent matters, and the London Commercial Court in fact released a statement highlighting the court's approach, and it said that the courts should be optimistic rather than hesitant, and that it is the duty of all the parties to seek to cooperate to ensure a remote hearing is possible. In fact, in one particular instance, a High Court judge recently declined an application to adjourn a trial, and this was in March this year, which was impacted by the lockdown measures. And it stated, the courts exist to resolve disputes, and that they should strive to continue to do so, even when that involves doing so by the way of remote hearings. In a first for the English Commercial Court, the trial was actually live streamed and transcripts published. Would we have thought that that would have happened earlier? Even say 10 months ago? No. I know that India as well, and the Indian Supreme Court has confirmed that it will continue to deal with important matters and has issued guidance for the use of video conferencing for all urgent hearings. But there seems to be some doubt, however, as to whether the Indian courts will continue to adopt virtual hearings. I was reading something that Justice D.Y. Chandrachud said recently, where he said that virtual hearings were no substitute for physical court hearings, which would be introduced once the crisis was over. I move on to the third topic, which is protocols. If virtual hearings became the norm, there's a host of refinements and adjustments that need to be made to tailor traditional procedural safeguards to the virtual hearing setting. There are a number of soft law instruments that offer helpful guidance on examining witnesses by video conferencing. By drawing from some of these existing resources, practitioners and arbitrators can make the task of actually organizing a case much easier without reinventing the wheel. And some of these include the ICC's Commission reports on information technology in international arbitration, the CIR guidelines for witness conferencing in international arbitration, the Hague Conference draft guide to good practice on the use of video links under Evidence Convention, and the Seoul Protocol on video conferencing in international arbitration. So just to take an example to address the concern as to the authenticity of witness evidence, Article 1 of the Seoul Protocol requires that the video conference system at the venue allow a reasonable part of the interior of the room to be shown on screen, whilst retaining sufficient proximity to clearly depict the witness. The witness will give his or her witness evidence sitting at an empty desk or standing at a lectern, and his face or her face has to be clearly visible. So moving on to the last topic, how can technology help with the type of disputes coming out of COVID-19? COVID-19 has obviously made it difficult for many companies, our clients, to perform some of their contractual obligations. And this has given rise to a number of inter as well as intra-company disputes, particularly relating to the application of force majeure and change in law provisions. Some of these disputes are significant, with potentially major consequences or financial implications. Some are less significant, but they all seem to turn on the same issues of construction and interpretation of relevant contractual clauses. Many companies have received force majeure notices, some have reserved their positions, some have sent similar notices back and reserved their rights up and down the commercial chain to preserve a back-to-back position. There are therefore a significant number of disputes that are waiting to be resolved, and this is obviously a big risk. But when these companies look at their contracts, what they see prescribed in their contracts is a formal, lengthy, costly mode of dispute resolution, such as formal arbitration. And so, what do you do? Because they want to resolve their dispute and they don't want to go down this formal, lengthy procedure. And the dispute revolves around contractual interpretation of certain clauses. So this has been recognized by some of the senior members of the judiciary. And so in the UK, they have called for commercial disputes to be resolved by mediation and other ADR mechanisms to avoid a deluge of post-COVID-19 litigation coming to the courts, which the courts just will not be able to handle. So in light of this, there are some new products that are coming out into the market. And one is one that just launched this week, I believe, or last week, which is the London Chamber of Arbitration and Mediation has developed this new product for offering expedited arbitration and mediation services delivered by a diverse expert panel of arbitrators and mediators with many years of experience in alternative dispute resolution. And this product is going to use blockchain technology, allowing the LCAM to provide fast and secure management delivery at a fixed fee. My firm as well, Norton Rose Fulbright, has developed a product called NRF Resolve. And this is an expedited legal framework for dispute resolution administered through an online platform, which will be supported by a Norton Rose case manager, along with a Norton Rose partner or pre-approved third parties, so Queen's Counsel, other solicitors, acting as conciliators, mediators, arbitrators, to facilitate an expedited arbitration or mediation within 5 weeks. And therefore, in conclusion, whether the old normal will return or the new normal will continue into the future, I guess is yet to be seen. But if I were a betting individual, which I'm not, but if I were a betting individual, I would say that what we will see is a hybrid between the old normal and the new. And hopefully this will lead to a better, safer, greener world around us with an efficient administration of justice. Thank you.
Thanks, Sharina. I think when you said about a greener world and reducing the carbon footprint, I'm sure many of the legal associates on this call are tuning into this webinar, applauding the thought of never having to do physical hearing bundles ever again. So part of the silver linings ahead. Thank you, everyone. Your questions are coming in. So take your time and type them out in the Q&A function, and we'll try and get to as many of them as possible at the end. Okay, moving on to Gauri, who's going to address third-party funding and the developments that have been taking place in India on this. Gauri?
Thank you, Smita. Good afternoon. It's a pleasure to be connected to all of you through Zoom. As you're aware, third-party funding is a very well-established practice in advanced countries, but it is emerging in developing countries also. I'm going to divide this topic into 4 parts: the legislative framework outside India, legislative framework within India, advantages and concerns of third-party funding, and impact of COVID on third-party funding. I'll start with my first topic, that is legislative framework outside India. As a start, I must mention that some countries do not allow third-party funding because it is opposed to public policy in those countries. Now, Ireland is one of those countries. There is a Supreme Court judgment of Ireland in persona digital telephony. In this particular case, the Supreme Court did not allow third-party funding. And the reasoning that has been given by the Supreme Court was that maintenance and champity remain tortious and offenses in that jurisdiction. And also another important point is that there is a prohibition of an entity funding litigation in which it has no bona fide interest. Third-party funding arrangements cannot be viewed as being consistent with public policy in that jurisdiction. These were the 3 important points that were laid down by the Supreme Court of Ireland. However, in this Supreme Court judgment, there is a mention of another judgment of the High Court in 2011 in Thema International. There is a very interesting carve-out that was made. The test is that sufficient connection with the claimant. That means whether you are a shareholder or a creditor, then those kind of funding arrangements are allowed if the company lacks funding. I must now point out that there are some countries which permit third-party funding on based on legal enactments, and there are some which are based on judicial precedents. Like Hong Kong and Singapore have permitted funding in international commercial arbitrations through legislations. As far as Australia is concerned, it has recognized the legitimacy of third-party funding, and it has held that it is not contrary to public policy. And the judgment is of Campbell, Cash and Kerry versus Fostiff. USA, it varies from state to state, and I believe Massachusetts and Carolina do allow third-party funding. I'm going to now elaborate a little bit of the precedents of the UK courts because they are very significant and they lay down the law very clearly on third-party funding. There's an important case of SR versus Norscott. This is of the year 2016, where in this particular case, Norscott got an award in their favor. And when they got the award in their favor, the arbitrator also awarded costs of third-party funding. SR challenged it and the matter came before Queen's Bench Division. And SR's argument was that other costs do not include third-party funding costs. But the court gave conclusions, and the conclusions are very interesting. Therefore, as a matter of language, context, and logic, it seems to me that other costs can include third-party funding costs. Here, there is an interesting remark by the judge when I was reading the judgment is that the requirement of reasonableness can act as an important check and balance over here. Then there are other two judgments of the UK courts of 2005, Arkin versus Borchert. In this, there was an Arkin's principle which provide for costs only to the extent of funding. This has somewhat been diluted in a recent judgment of the Court of Appeals in 2020, which is Chapelgate judgment. In that, they said that the Arkin's principle is not redundant, and they gave a discretion to include other matters other than funding costs. I will also now come to an important aspect that many institutes like arbitral institutes have also provided rules for third-party funding, and these are more in the nature of disclosure requirements. Like SIAC mandates disclosure requirements of third-party funding in investment arbitrations. HKIAC, ICC task force also provide for such requirements in their rules. Now I will come to my country, that is India, and I must point out what are the rules or precedents in my country. Third-party funding is allowed in litigation, and some states have made amendments in their code of civil procedure. And but however, the requirement that is there is that the payment of security cost is to be, which is incurred, is to be deposited, it has to be deposited in the court. While dealing with the issue of foreign lawyers practicing in India, the Supreme Court has, in a judgment of 2018 in AK Balaji, have pointed out that while lawyers are not allowed to fund litigation, but they go on with the reasoning and say that there appears to be no restriction on third-party funding when there are non-lawyers and funding the litigation and getting repaid after the outcome of the litigation. So this is an interesting development, but it is 2018. I will also point out an interesting case of the Supreme Court of India in 1955, where they said that third-party arrangements or agreements are legally enforceable in India. Apart from that, the only carve out is that legal practitioners cannot fund. That is the carve out in this judgment, because it would be opposed to public policy. There is the judgment of the Privy Council, which I'm going to cite, which becomes important is it is of 1876. And why that judgment becomes very relevant is because in this particular case, they laid down 3 factors. And they said these are the 3 factors which are opposed to public policy where looking at third-party agreements. One is that the agreement should not be extortionate, it should not be unconscionable, and it should not be inequitable. So these are some of the grounds which they laid down regarding which is contrary to public policy. As I had pointed out that in the UK case, Northcott, SR versus Northcott, that particular case has come for enforcement in India. Initially, Northcott filed for enforcement in Hyderabad, but then they withdrew that application, and I understand now the application has been filed in Mumbai, and there has also been an injunction application that has been filed by SR, which says that the oil rigs should not be taken over by Northcott. But the ground that SR is taken is, which is opposed to public policy, is that the act is champetous and it is opposed to public policy. So SR is contesting the enforcement by Northcott in India. And let's see how this particular decision, or when it comes, plays out in India. Now I will come to my third aspect, which is that while there are advantages of third-party funding because it frees up businesses of funds, there are some concerns that are required to be kept in mind also. One is conflict of interest between the funder and the arbitrator. Then there are disclosure requirements, like I pointed out in the institutes where there are mandatory disclosure requirements. If you have gone for a third-party funding, it is important to make those disclosures. Third is security of opponents, like I pointed out in India, is to be deposited in the Supreme Court. Sometimes if you feel that settlement is sometimes third-party funders don't like, they avoid settlements because they make their money on the damages that come in or the claims. So settlement is something which businesses need to look at if they would like it in their agreements. Then if you are in a seat of arbitration which allows third-party funding, you should equally be careful of the fact that maybe when you enforce that award, that particular jurisdiction may not allow third-party funding. While the arbitrator can give you costs of third-party funding, if the claimant wins the arbitration, there could be adverse costs attached if the claimant loses the litigation. Then the defendant's ability to pay is one of the reasons which the funders look at when negotiating contracts with businesses. This brings me to my last point, which is the impact of COVID. Now, I feel that COVID has had a drastic impact on the economies of the world and which has left litigants, especially corporates, short of cash. Now, this, according to me, may enhance the bargaining powers of the funds. Therefore, I would like to now conclude by saying that the momentum seems, especially across the world or whatever I've been seeing, towards greater acceptability of third-party funding. And after the enforcement in the SR's case, I think we can expect greater progress in India also. Thank you.
Thank you, Sharina. Before we wrap up this point, I was hoping that Anu, you could also share some observations you have on this topic, on third-party funding.
Sure. Actually, Gauri has really given us a broad overview of the subject. But see, as we are seeing the world, and particularly cross-border disputes, we are seeing people like to settle it through arbitration. I think third-party funding is becoming increasingly more important. But the issues, apart from what Gauri pointed out, I think are that, only Singapore and Hong Kong have regulated. Many other countries haven't regulated. So the question will arise whether is the law regarding third-party funding on where the arbitration was held, that is the seat, or will it be where it is to be enforced, or will it be where the law of the disputes is to be settled? So these issues will come about. And there is no doubt that in third-party funding, the person who is funding does take a risk. And in fact, there is one of the cases where one of the Burford Capital, it got 700% benefit out of it. Well, so be it. As long as people get access to justice. I mean, what is arbitration? What is litigation? It's access to justice. Now, if third-party funding gives people access to justice, I think it should be allowed. But yes, it must be regulated so that, there is uniformity everywhere. In fact, in India, there is a committee headed by Justice B.N. Sri Krishna, a high-level committee regarding institutionalization of arbitration mechanism in India. And that in 2017 has suggested that you must have a third-party funding, you must allow it so that it will give boost to arbitration in India. So in my view, it's not only arbitration, we should allow it in litigation, particularly in India where there's a lot of poverty and access to justice is expensive. That's where we should allow. It will give access to justice to all. So I do agree with what Gauri is saying, that all countries, according to me, should regulate, permit, but regulate and give people this access to justice.
Thanks, Anu. So while we are still on third-party funding, I thought we could take some of the questions from the audience on this topic, and then we'll work our way backwards up towards the other topics. So, first question, and this is to Gauri. Does third-party funding alter the basis of confidentiality between the parties?
Yes, it does to an extent, but I think it is important also to strike a balance. And I have always been, if mostly businesses are strapped of cash and don't have too much of cash also, confidentiality is something, but then there are already agreements between the funder and the businesses which provide for confidentiality clauses. So it is a concern, but I think the third party funding of not allowing it only on the grounds of confidentiality is something probably we should not give it so much of importance, because there's already an agreement between the funder and the business.
Smita, I would just add here that these are issues you regulate. Probably,
Yes.
you know, instead of attorney-client privilege, allow a third party to get into that arena and give, so that he can't say it out. He can't leak it. He also gets bound. So maybe these are areas which need to be worked out.
Now that's a very good point. One more question on third-party funding before we move on to investor state queries. Okay, for both of you, Anu and Gauri, do you see an increase in third-party funding in India to maintain business operations in light of the pandemic?
Yes.
I must. Okay, sorry. Go ahead, Anuradha. Please go ahead.
Okay, we'll go with Anu first, then Gauri.
So I think, you know, as Gauri already pointed out, that there is going to be people are going to have less resources, and this may not be really your focal point. You may want to have resources to pay salaries or run the factories, which is more important. Litigation, arbitration may not be your. There, you know, there is where you can really get help from third-party funding. So I'm hoping that people do resort to this mechanism to access arbitration, litigation, etc.
So hopefully, because of the pandemic, the cost of it, even if it's 700%, will not be seen to be too great in the grander scheme of things.
Well, Smita, if I can get my 100 rupees and somebody makes 500, I'm fine.
Sorry?
So I would just like to add that it is too early to say whether third-party funding is becoming more prominent in India because of the COVID situation. We have been under a lockdown. Courts are only looking at very urgent matters. Many institutes don't provide for online arbitral hearings also. So it obviously, like I would actually go by what Anuradha Dutt has just mentioned, that we will see more of these in the future. And since companies will need more funding and they would like to employ the funding that they already have in better things, in capital resources in their own companies, we'll see a rise. But right now, because of the lockdown, it seems it's very early for us to say that we have seen a rise in third-party funding.
Thank you. Okay, moving on to Sharina, some questions for you. The first one being, are virtual hearings working well in international arbitration, in your opinion? I mean, you went into some detail when you gave us your very clear talk, but generally, just as a litmus test, would you say they're working well right now?
I think it depends on who you ask. I think generally, yes, it's working well, but I think we're in a different situation to what we will hopefully be in the future, because we're all doing these hearings from home, where we haven't really got that upgraded technology. We've had poor connectivity issues sometimes. There's quality issues, there's reliability issues of sound and picture quality and lag. I did 2 hearings during this period. One was fine, the other one, technology issues. So, but you know, I think I think when we're out of this, and we're not going to be doing these hearings from home, but actually from proper places, you know, where there will be better connectivity, I just think it's going. I think it's somewhere where I think that's where the future is. At least for some of, let me say where the future is, maybe not for the final hearing, but maybe the run-up to the final hearings. You know, the procedural hearings, the disclosure hearings, the run-up.
What about the evidentiary value of witness examination? I think that's the main con that most people have cited when they say what bothers them about virtual hearings.
Yes, I mean, I think I touched upon that because, you know, that is where, it's funny because I was talking to one arbitrator and he said, actually, I quite like the virtual hearing because I can look into the eyes of, of the witness online and I can zoom in. But the others felt kind of what I said, you know, you lose that feel, that touch, that the nuances, the body language, I think you lose that online. So I think that could affect, and that's why, you know, I prefaced my earlier point, which was perhaps virtual hearings are here to stay, but maybe not for every final hearing.
Thank you. All right, moving on to Claudia, some questions for you. The first being, would an EU investor who invested pre the ACMEA decision still have a remedy before an investor state tribunal to invoke the sunset clause against measures that affect their investment?
Sorry, I'm trying to unmute. Could you repeat the question? I'm very sorry,
Sure.
It broke out. In the...
Sure, no problem. Would an EU investor who invested pre-ACMEA still have a remedy before an investor state tribunal to invoke the sunset clause against measures which have affected their intra-EU investment?
According to the terms of the termination treaty, which is implementing the ACMEA judgment, such an EU investor would no longer have a remedy under an intra-EU bilateral investment treaty. So under ACMEA, it would still be open to the investor to go before the domestic courts of EU member states, or to the extent available to the European courts in Luxembourg, the European Court of Justice and its General Court. But these are quite different causes of action. You would have to rely on EU law and a cause of action that is directly available to an investor in order to bring a claim. And of course, we know the causes of action directly available to private parties are quite limited under EU law. In general, a private party would have to lodge a complaint with the European Commission, and it would be up to the European Commission to pursue or not to pursue the claim against the EU member state.
Thank you, Claudia. One more question for you before I go on to Anu. With states suggesting domestic courts should decide BIT claims, does it violate fundamental principles of no one can be a judge of our own cause, since under international law, the judiciary is part of the state?
I'm not sure I would put it in such harsh terms. As a matter of fact, feedback from users very strongly suggests that investor-state arbitration should be maintained and provides a neutral forum, and that most investors do not feel comfortable to litigate before the domestic courts. There is no doubt that the domestic courts in EU member states, or also in the UK, in other countries like the US, Canada, they are independent courts. All the constitutional guarantees apply to their proceedings. But at the same time, I think there's quite some reluctance. First, these courts are state organs of the respondent state. And so there is at least an appearance that these domestic courts may not be entirely independent in deciding an investment treaty dispute. Then there is the question of the level of efficiency of domestic courts. That varies a lot, even within the European Union, and even the European Commission would recognize that there are certain member states whose judiciary does not work as effectively as that of other European member states. The third question is a more general question, the experience of judges. Investor state arbitrators are typically very experienced and are specialized in investment arbitration, in international investment law, international trade law. Unless there are specialized courts at the domestic system, you would lose that experience. And only, I think, one of the most important questions is what is going to be enforced in domestic courts? Is it investment treaty protections that would be enforced by investment treaty tribunals, or is it something else? And the termination treaty currently foresees that investors would not be able to just enforce investment treaty protections in domestic courts, but they would have to enforce causes of actions already available under domestic law or under European.
Thank you. Anu, there's a question that's come in for you. Is it easier to enforce an award made by a tribunal seated in India, i.e. a domestic award, or an award made by a tribunal seated abroad?
That's a difficult question to answer because it'll also, let me say to you, it'll also depend on court to court. Unfortunately, you know, India is so large and there's so many courts where these things go. But what I'm seeing today is there is a trend in foreign seated arbitrations. When those awards come, the judges are stricter in you know, seeing the objections. So there's a narrower scope of allowing objections. So if I have to answer, I would say it's easier to enforce foreign awards than domestic awards.
Thank you. Okay, we have time for one more question, and this question has been sent to me privately. I think it's because we're an all-female panel. So this is open to everybody on the panel. Is the international arbitration community doing enough to promote gender diversity? And what further steps do you think should be taken? We'll address this in turn. So Sharina, would you like to go first?
I think it is. I mean, there is the Pledge initiative. I'm on the steering committee of the Pledge, and actually I launched that in India 2 years ago. And it's been hugely successful. In fact, last year, end of last year, I ran 2 dinners in Mumbai and Delhi for 20 women, junior, mid-level, senior, and they were a huge success. And actually these dinners have spun off with people meeting. People have written to me saying they found mentors. People have, there were GCs at the dinner, there were juniors at the dinner, there were solicitors, barristers, and actually it's also generated a lot of workflow. So I think there's been, there is a huge push for gender diversity, and I have to say, I've seen that from the arbitral institutions and the figures as well. Each of the arbitral institutions have been releasing some really amazing figures showing the increase in the rise of female appointed arbitrators. But interestingly, the rise is from the institutions appointing the female arbitrators and less so from parties. And therefore, I think there's more work to be done.
Sharina, that's a really good point, because I read some statistics recently, I think it was a year or 2 years ago, which showed that female arbitrators are often, or tend to be more often, appointed by parties or by the institution. But where we rank very low in terms of appointments is where co-arbitrators decide on the chair or decide on the third arbitrator. There, if the co-arbitrators are not female, or even if they are, I don't know, but the statistics are quite disappointing on that front. So just some food for thought.
Can I say something to that, Smith? Actually, that's such a good point, because actually what we've started doing as a firm is actually very politely writing back sometimes when there are 2 male arbitrators who have sent the list for the chair, which contains a list of, say, 6 males, and significantly women are missing. And we write back a very polite email saying, we as a firm are signatories to the pledge, and may we suggest that these individuals who are women, as outstanding as the men on your list, be added to the choice given to both parties. So that's just a practical
I like
tip.
that. Claudia, I mean, Germany's never shied away from strong women leaders. So what are your thoughts on this?
I fully agree with the observations that were made so far. I think that arbitral institutions are doing a great job to promote gender diversity. And the problem is with co-arbitrators and private parties. Now, from the perspective of counsel, I myself sometimes see pressure from private parties to go forward with a male arbitrator or a list of predominantly male arbitrators. It's a chicken and egg problem that you find a long record currently, particularly in investor-state arbitration, predominantly with male arbitrators and only a few female arbitrators. Now, I think we have to be careful also what we're doing in the future. The future system that the EU is creating in terms of an investment court system, where we will see rosters of arbitrators or panels of arbitrators appointed by states and the parties. It has been quite disappointing what has come out more recently in terms of appointees suggested by the European Union, where we saw 1 or 2 women and the rest of the appointees being male candidates.
Thank you. And Gauri, can I have your views? I mean, India as well is well known for women CEOs. I mean, Pepsi was one of the shattering of glass ceilings you've seen. And in political positions, businesses, banks, everywhere, women are dominating. I mean, they are featured. So what do you think for international arbitration? Do you think more can be done? Or in India is there enough representation of gender diversity already?
Let me start by saying that litigation and arbitration, both professions have generally from the beginning been very male dominated. Especially I'm talking about my jurisdiction. But that's because many, if you see most courts, we didn't have many women judges earlier. Now you have more women judges in the court. With the result, now you have more women arbitrators also now. And it has made a lot of difference. So of course, things are changing. And while we talk about institutes and lawyers and litigants or litigators, I must also mention that even in other sectors, the government is also promoting women, whether it's defense, whether reservations in parliament, and in higher positions in government. We as Cyril Amachand, even in our law firm, we promote women, and almost 60-65% of women in our organization are in managing roles or in senior partnership roles. So I think there is some ground, a lot needs to be done, but we have already done a lot here.
Thank you. And Anu, I mean, your firm is founded by 3 strong women, all of whom are very active and well known in international arbitration. So can you round off the panel session today with your perspective?
So, well, to my mind, there has to be an attitude change in the society. Okay, so as long as India's society doesn't open up, doesn't give enough, opportunity to women, we'll always have this imbalance. This is a process which, as the other 3 mentioned, has started, but in India, as long as we, have women playing a secondary role, this will be a problem. And let me give you a small example. Now, say if I am born, I have a brother, lots of families in India, the brother will get more than the sister. So the inequality starts here. And if I suppose I'm a lawyer, I do my law, I start practice, I get married, then 60% or 50 or 60% of women just are forced to stay at home, look after children, look after the home. So, you know, the women lawyers just don't get that opportunity after their marriage. Then they have children, then they have to look up. So it's our society has to change. And as our society changes, I'm hoping that this gender inequality will also change.
Thank you. And on that note, we finished the webinar today. We've run out of time. Apologies to those whose questions we did not get to. This video will be made available on the SIAC YouTube page. And if you want to know the answers to your questions, feel free to email the panelists. Thank you, everyone. And a special thanks to the panel. Thank you for a very engaging Saturday afternoon. Thank you, everyone.
Thank you, Smita, and thank you, SIAC. And thank you, fellow panelists.
Thank you. Thank you.
Thank you. Bye-bye.
Bye.